staff, and also including about 30 PhDs. And we have 13 research groups.
I really must come over to your campus sometime.
Yes, we will because we are organizing our international research conference in November.
Sure.
So we will invite you for that. Probably we are planning on having a panel discussion, and for that I'm planning to invite you.
Oh, lovely! Thank you.
So even last time we had it, even last time we got some international papers as well, and there were some international participants who came to Colombo. Power issue. Okay, thank you. Power issue Mr. Revan.
So sorry, Lakshita. My lights went off. So I immediately switched on to the data on my phone. Am I audible?
Yes, it's very clear.
Okay, that's good to know.
Okay, I think we can start now. If you're ready, Revan, I'll introduce you to the audience.
Sure.
So this is the 7th session of the Emerging Scholars Research Program. So this is a program where the undergraduates get an opportunity to learn about research. And once this program is done, they'll be allocated to research groups. So most of these undergraduates are in their second year. So what we wanted to do was to train them on research while they are in their sophomore year, so that they will have 2 more years to do research under a research group. The university has now 14 research groups in totally different areas, ranging from agriculture research to IT, engineering, to business-related research. So we have a lot of cross-collaboration within the university, and also now we are planning on going out and then find collaborations even from outside the country. And also we are tagged as a research university, SLTC research university. So we want to give this opportunity to students so that while they are doing their undergraduate studies, they will get an opportunity to do research. So I will introduce today's speaker, Mr. Revan Weerasinghe. So today's session, we consider this as a very important session. And so the recording will be shared with all the academics and also in LinkedIn account. Today's speaker is Mr. Revan Weerasinghe. He's an independent legal practitioner with expertise in intellectual property, privacy law, information security, data protection, company law, environmental law, and commercial transactions. He acts as both an advocate in court and a consultant for business and startups, helping them with intellectual property strategy, data protection, and creating environments that support innovation. Mr. Weerasinghe is a co-founder and a counsel at Insight Legal, a legal firm, and has served as the consultant legal and intellectual property advisor to the Sri Lanka Institute of Nanotechnology for over 15 years. I personally know the service given by Mr. Revan Weerasinghe to SLINTech, because SLINTech being the most advanced research institute in the country, and also the only research institute which is focusing, of which the revenue generation model is based on creating intellectual properties and transferring intellectual properties to the industry. IP is a very important thing. So Mr. Revan handles all the IP related matters, all the agreements, negotiations. So he's doing an immense job at Slintech for over 15 years. And he holds a master's in law from the University of Colombo and LLB in law, a BSc in information systems and management, a diploma in economics from the University of London, and a post-attorney diploma in intellectual property from Sri Lanka Law College. He has also completed a certificate course on technology licensing from ITLO in Rome and participated in a World Intellectual Property Organization Summit in Japan. In addition to his practice, Mr. Revan Weerasinghe lectures on intellectual property law at the Postgraduate Institute of Management, PIM, as we know, and ICLP Arbitration Center. He was named one of the top 50 emerging IP players at the IPR Gorilla Conference in Dubai in 2019. So, Mr. Revan Weerasinghe, over to you.
Thanks, Lakshita. Thank you, everyone, for this fantastic opportunity. And thank you, Lakshita, for this opportunity to discuss one of my favorite subjects, which is IPR. I think there's a time limitation of about an hour. So I'll try and make this quick. But why I say this is one of the most beautiful areas of law is that it is also one of the most potent or productive tools for profit generation the world over. Right? And if you look at many successful economies, you would see that royalty income or income generated from intellectual property is a significant component of how those companies, countries and companies have excelled through time. And the funny thing is, the more you deep dive into intellectual property, you will realize that we are no strangers to IP. We use IP in our day-to-day lives. We use IP in everything we do, and we see IP all around us, everywhere. So intellectual property is found predominantly in 4 types of intellectual property. There are 4 major headings of IP that I will talk about today. Apart from that, there are several other rights that are found in the Intellectual Property Act. And you will see that IP is also an international covenant that is recognized the world over, right? With certain limitations that I would go into. So I'd like to start this lecture by saying IP is a very, very powerful tool for profit generation and productivity. And that is what I'd like to base the foundation of this lecture on, right? Like I mentioned, there are 4 types of IP. I will go into my presentation in a bit, but there are 4 types of IP. One is copyright, one is trademarks, one is patents, and the other is industrial designs, right? Apart from that, you get IP related to know-how. And if you're a technology campus, you're going to use all 4 of these different types of IP. And I think it's important to really see them as tools to create an overall product that has value in the market. Now, if I'm to start this lecture by talking about, say, Coca-Cola, or any product that you can think of. You can throw any product to me, Microsoft, any product out there, and I will tell you how you can break that product down into several components of intellectual property. Now, Coca-Cola, as you can see, you see the product on my slide, which is there in a bottle, right? Then you also see the Coca-Cola trademark, right? Now, I remember listening to a case in the Commercial High Court of Sri Lanka on Coca-Cola, right? Where Coca-Cola was suing this company called My Cola. Now, they sued My Cola on the basis that My Cola used the same stylized fonts and imagery of Coca-Cola to put out this product, My Cola, which was a product in the local market. Now, I remember the witness for for Coke came. He was a lawyer, I believe, from India, because I think India is a distributory arm of Coke. This gentleman was put on the stand, and he was trying to talk about the value of Coca-Cola. So he said, Your Honor, do you know, next to the cross of Calvary, right, which is the Christian cross, in his opinion, the most recognized trademark in the world, or the most recognized mark in the world, is Coca-Cola. And that was his testimony before court. Why I'm illustrating this point is, trademarks have value. And companies, over time, their trademarks have more value than most of the assets in the company itself. Right? So if you are to value the asset of the company, it's very important to also value the asset, the value of the trademark. So that's what trademarks are. And I'll go into this in detail. So in the other picture, you also see the Coca-Cola formula, or the Coca-Cola drink. Now, do you know that for the Coca-Cola drink, you do not have a patent? Coca-Cola is one of the few, or not few, but it's a very well-known example of a trade secret. And the formula that goes into Coke that gives it that feeling, people have speculated over time, maybe the last century or last couple of decades, as to what really went into or constitutes the Coca-Cola formula. And they chose not to patent it, but they chose to keep it as a trade secret, simply because they wanted to keep this product for more than 20 years, because as you know, a patent is only used for 20 years. Then apart from that, you also get what's known as copyright, and you also get what's known as industrial designs. I will go into that. Each of these are tools that is used for profit generation. Now, why do I keep on saying that they're tools used for profit generation? The main reason I say that is because by the intellectual property mechanism, you can license the IP or the usage of the IP for profit. And if you look at, say, many successful economies the world over, and if you break down what their countries or their companies actually sell, the companies in their countries actually sell, you would see that there is a great investment in intellectual property, and they leverage highly on intellectual property for the purpose of profit. So without further ado, I'll start my presentation on the subject of IP, right? So prior to talking about IP, let's delve a little into the concept of value, right? It's important to know what gives something value, right? One way of appreciating value is the demand that a certain product has in the market that gives it its value. Another way of determining value would be the functionality a certain product, goods, or service has in the marketplace. Now, what gives intellectual property additional value? What gives the product additional value via intellectual property? Well, one way of understanding that is intellectual property gives you ownership to what you're about to create. And by owning that, you can control the subject matter. You can control that piece of property. And that alone can give it value because you can control this, the supply of such a product in the marketplace. Let's keep this idea on hold for the moment and deep dive into what IP is all about. Before we go into what IP is all about, right? Note the word intellectual property. I think it's important to know what property is. Property, according to the Oxford Dictionary of Law, means anything that can be owned. It can be tangible or intangible. It can be bought, sold, or exchanged. It can be licensed, leased, or rented. If you have a house, it can be sold, it can be leased, and it can be rented, right? So that's the same basis in which we should try to understand intellectual property. It can be bought, it can be sold, it can be exchanged, it can be licensed, right? Those are pretty much the terms we use in pertaining to IP, right? Transfer of IP, selling or exchange of IP, licensing of IP. Only thing, IP is not a tangible thing. A lot of people consider IP a tangible thing. IP is actually a bundle of rights given by a state to say you own this intangible set of rights. Why do I say it's intangible set of rights? Because it is rights, and rights are not tangible. So you have rights to the book you wrote. You have rights to the photograph you took. You have rights to the invention you created. You have rights to the trade secret that you created, well, by certain limitations through the Intellectual Property Act. You have rights to an industrial design, and you have rights to the trademark that you created. Now, why is it intangible? Because finally what you have is a bundle of rights. Yes, there might be a signboard that has the trademark, but finally what you have is a right to have exclusive use to that trademark in the country in which you registered that trademark. I think that's an important premise to understand before we go into the lecture. Now, that is what intellectual property is all about. It is a bundle of rights. And I think we'll start with that premise. Now, you can see that intellectual property includes, there are 4 types of intellectual property, as I mentioned at the introduction. It includes patents, copyrights, trademarks, and industrial designs, right? It is once again granted by law and enforced by state. Now, trademarks, industrial designs, and patents, you have to actually go to the registry. In Sri Lanka, it's the National Intellectual Property Office, NIPO. You can go and check the website if you want on more further information. And you lodge an application and you get what's known as a trademark or a patent or an industrial design. So it is granted by law and enforced by state. Copyright as well is granted by law because finally you derive your rights by the Act of Parliament, which is Intellectual Property Act number 36 of 2003. That is the law that gives all intellectual property in Sri Lanka its rights and basis in law. Now, before we move any further, whilst we have the law in place in Sri Lanka, every other country that has agreed to several international covenants like the Berne Convention or the TRIPS Agreement, right, have also agreed to have similar laws in their countries to guard and protect intellectual property and enforce such the rights of intellectual property owners, right? So IP is firstly granted by law and enforced by state. It is generally granted by registration. However, in the case of copyright, there is no registration. I will go into that. Now, that is the introduction to the 4 types of IP there are. Now, let's talk about one of the most common types of intellectual property, which is copyright. Copyright is, you would find it in, like I said, in everything around you. You find copyrights pertaining to music. You find copyrights pertaining to plays. You find copyrights pertaining to software. Books, photographs, sculptures, paintings, drawings, choreography, movies, recordings. So now if you talk about economies, like I did at the start, you would see that the American economy derives a lot of its revenue through royalties pertaining to so many of the things that are illustrated right now. Software, music, movies, right? All that has ownership attached to it. So therefore, if I am to watch a movie belonging to, produced by someone on Netflix, I pay Netflix use of that to watch that movie, and in turn, Netflix pays the owner of each of those audiovisual works royalties for allowing Netflix to air that movie to its subscribers. That is what you call a back-to-back license, or that is what you call a license agreement. It is permission to view, or permission to use, or permission to use, I would say, in this instance. Right? Now, there are several interesting cases also that have gone with in relation to a lot of copyright. I'm currently doing a case pertaining to a musical work, the use of a song. It's a very interesting case where someone has taken the song, changed the lyrics, changed the music a little, and has put the song out the public domain, claiming that song is to be theirs. But the Intellectual Property Act has something called substantially taking, where you can't substantially take the works of someone else, and even that would constitute copy. So so you get a lot of cases in relation to copyright and in relation to music. To give you another example of a copyright case, interesting. There was Andrew Lloyd Webber had a production which is called Phantom of the Opera. There was a Sri Lankan company that tried to put Phantom of the Opera on boards at the Lionel Went. Prior to it being performed, they got a letter of demand from Andrew Lloyd Webber's company saying, please cease and desist from using our copyright material to perform the play Phantom of the Opera because it belongs to Andrew Lloyd Webber. So as you can see, copyright is essentially a bundle of rights. It's a bundle of rights that either protects music, movies, software, or anything. So if you are the owner of this bundle of rights, only you have a right to ensure, to allow usage of that particular work. It's only with your explicit permission can someone use it. Can someone even play it? Can someone copy it? Because it's called copyright. You have the right only to copy this. You have the right only to allow someone to copy this. You have the right only to license this work if you are the copyright holder. Right? Moving on. So what is copyright? It, like I said, it protects books, articles, software, speeches, lectures, dramatic productions, musical works, audiovisual works, drawings, paintings, sculptures, architectural works, photographs, maps, plans, sketches. However, the fundamental ingredient of a copyright is that it has to be original. You have to be the original creator of a copyright work. And you have to establish that you created the work and not someone else. Now, unlike trademarks and industrial designs and patents, where you have to go to a registry and apply to be granted rights, here your rights accrue by the sole fact of its creation. So I may be a terrible artist, but when I put paper to pen, however bad my drawing is, I would be the person that owns that piece of work, right? So it's protected by the sole fact of its creation, irrespective of its form or mode of expression, as well as its content, quality, or purpose. Sorry. However, it's only granted upon expression, right? That's another thing you have to know. Now, I may have a copyright, I may have an idea of a book in my head. Excuse me. Or I might make a poem. I might think of it in my head, even say it to myself about 5-6 times, this poem. But if I don't put it on a piece of paper, I would not be expressing that idea, and there would not be expression in terms of the law. So for there to be copyright, firstly, you need to express it on a mode of expression, right? That can be a piece of paper, that can be a software, that can be a photograph in a digital form, or in a painting form, in a picture form. However, it has to be captured somewhere. And after I create it, there has to be creation, right? It's not just ideation, but it's creation. After I create it, or express it, it's granted for my lifetime plus 70 years, right? Granted for the lifetime of the author plus 70 years. Now, that is in relation to copyright. Now, before I move on to trademarks and industrial designs and various and the other aspects of this presentation, let's talk a little bit about some other famous cases of copyright, right? So now you can see there was an interesting case called the monkey selfie case. The monkey selfie case is where a monkey went up to a DSLR camera that was on a tripod, and he pressed the shutter. And the photographer was absolutely amazed by this photo. And he put it online saying, this is the monkey selfie case. This is a monkey selfie. This selfie was taken by a monkey, right? Then there was an environmental organization called PETA. PETA got in touch with this photographer and said, look, you don't have rights to this. The actual owner of this photograph should be the monkey, right? And they sued on behalf of the monkey. Or they sued saying that this right should not go to the photographer, but this right should go to the monkey, right? And this person, anyway, it was just an interesting case. It was an academic case called the monkey selfie case. You can Google it. At that point, court gave a judgment saying, no, given the skill that was used by the photographer to set up the camera on a tripod, allowing any person to click the button, copyright should accrue to the photographer and not the monkey, right? So that's just an interesting case I wanted to drop in there just for people's curiosity to get an idea of what copyright is all about. But now we are going into a new world, should I say, especially with artificial intelligence coming to the forefront, where people aren't going to be sure as to who really created the piece of work, whether it was created by an author or it was created by a machine. I may tell a machine, an artificial intelligence machine, create me a picture of a famous politician in the style of Walt Disney, right? And the machine might draw it in this beautiful manner. Now, who then will own the copyright? It's just an interesting debate. Is it my skill with regards to prompting, or is it the machine or the owner of the machine that would have rights to the copyright work? Now, in relation to that, of course, the jury is out there because we haven't had a case on point. But it'll be interesting to know how copyright would survive the artificial intelligence sort of race. Because in future, all of us will use AI to create a lot of our copyright generated work. Now, there was a case in England, however, in relation to copyright, where an AI engine used to use copyright material that was contained on a legal website, that had a repository of legal articles, legal opinions, and accent cases and various things like that. Now, this AI was not stealing, but using the work that was contained on this website to generate its own copyright. This was finally challenged in court, and it was said that the copyright belonged to the legal website, right? So, like that, there are many different interesting cases with regards to copyright, but copyright actually is one of those amazing tools by which many economies have a lot to thank for in terms of profit generation. So now let's go into trademark. Now, I already gave you an example of trademark. In this slide, you see several examples of trademarks, such as Coke, Google, Facebook, Twitter, Amazon, Adidas. They're all very valuable trademarks, right? These are very valuable trademarks. If you go to look at the value of, say, Nike or Coca-Cola, it will probably far exceed all the assets or most of the assets of the company. Probably all the assets of the company. And most of the most fought over cases in companies are fought over trademarks. Now, sadly, some people don't realize the value of a trademark when they start the company, and some companies keep on changing the trademark. Now, that I would say is a very bad idea, because the importance of a trademark is that your trademark accrues goodwill through time. Now, goodwill or badwill, right? But if you keep on investing and performing well to maximum capacity, and you give a good service to the public, and the public recognizes your products to be of significant value. Like, for example, Nike. Nike is a shoe product that a lot of people consider to be of a very high standard. So then, if, say, I copy Nike mark, right, then technically I would be piggybacking, or I would be trying to exploit the goodwill and reputation of Nike by creating a spin-off company, right? Which is why counterfeit products are so valuable, because even if it's a counterfeit and you have the Nike logo on it, people think, wow, this guy is wearing a really good quality t-shirt. It may be fake, right? Which is why companies like Microsoft, companies like Nike, spend so much of money trying to get the counterfeits out of the market, right? Adidas. So trademarks is also another very important area of law and intellectual property that we need to go. Now, how do you get a trademark? Trademark is either right, once again, granted upon registration. So you have to go to the trademark office and apply for it. It is a mark. It is predominantly a business identifier, and it is granted upon conforming to the sections of the IP Act. Right now, the section in Sri Lanka is 103 and 104. They give certain requirements. For example, you can't apply for a trademark of a company that already exists. You can't apply to register a trademark of a company that used to, of a mark that used to exist. Or you can't apply for a trademark for a mark that is scandalous or is against morality, right? Like that 103 and 104 has the whole list of do's and don'ts, or don'ts, should I say, where you will not get a trademark if you apply under that in violation of 103 and 104. So when you're applying for a trademark, it is good to go under the advice of a lawyer who will look at 103 and 104 and look at your mark and say, look, is your mark a good mark or a bad mark? Now, what would be a good mark and what would be a bad mark? Now, that's also another question that we need to, I'd like to spend a little bit of time on. But prior to going into that, I would like to say trademarks are granted only for a single territory. So if I get a trademark in Sri Lanka and apply for it in Sri Lanka, I would not get that application in different countries unless I go to each of those different countries and apply for the trademark in all those different countries, right? You only get it for a single territory, which is something you need to know. Now, getting back to the question of what constitutes a good mark and a bad mark, well, a mark has to be distinct. And this is what 103 and 104 tries to overcome. For example, a mark cannot describe the goods and services that you're trying to sell. Now, examples of what I consider a bad trademark would be something like even Burger King, right? Burger King, it's only the two words put together that have some form of exclusivity. The company should not and do not have rights to the word burger, right? Neither would they have rights to the word king, most probably not, right? They only have rights to the word Burger King as in put together, but that is a weak mark. You can distinct, an example for a distinct mark would be something like maybe Odell, right? Odell is a fairly distinct mark because it doesn't mean anything, right? Sony is a distinct mark. Samsung is a distinct mark. Toyota is a distinct mark, but however, we must go to see whether it has specific meanings in Japan, right? Now we go to what is a patent. But before we go into a patent, to recap, to obtain a trademark, you need to go to the IP office, apply for a trademark, and your trademark should be in conformity with sections 103 and 104 of the Intellectual Property Act, right? To obtain a copyright, right? You just need to create it. You just need to create it, but you need to prove to a court that you created this, right? And not somebody else. Right, now we're going to a patent. Now, being a technology campus, I'm sure most of you all are interested in getting patents, right? So a patent is once again a right granted by a state upon application by an inventor, which gives an inventor exclusive rights to the invention. Just like trademarks, these, you only get rights to a particular country, right? You don't get, just because you apply for it in Sri Lanka, you don't get universal rights. If you are to get it in if you want your product to have these rights in different countries, well, then you need to make applications in different countries, in all the countries in which you want to get rights to, right? So your patent, once you apply for a patent, the examiner or the IP office would study your patent application under the premise of whether your patent is novel or not. They look actually for three things: novelty, inventive step, and whether it's industrially applicable. Novelty, I will go into the test in the next slide. Basically, you have to demonstrate that your idea that you're seeking protection is the first of its kind in the world, anywhere in the world, and it's not found anywhere in the world, right? If it's found anywhere else in the world, and if people do a patent search and find your idea or your invention somewhere else in the world, they're not going to give you rights to your patent, right? So if you can prove to the examiner that your invention is novel, and then has an inventive step, it is actually inventive in terms of what already exists in the prior art. There has to be an inventive step. There has to be something inventive. It cannot be an obvious iteration of what already exists. And if it's industrially applicable, then the IP office will grant you the patent for 20 years, provided necessary necessary fees are paid in the IP office and the patent is not nullified in a court of law, right? Now you can get that for 20 years. Now, both patents and trademarks, sometimes, excuse me, if you forget to pay necessary fees, as may be stipulated in the act. Now, a lot of people make this mistake. They get the patent to their hand and then they completely forget to pay fees, annual fees, right? If this happens, your patent or your trademark might lapse. Copyright doesn't lapse, but trademarks and patents and industrial designs would lapse if you do not keep your right afloat in the IP office by paying necessary fees. That is very, very important. Requirements to obtain a patent, what I just discussed, must be novel, must involve an inventive step, must be industrially applicable. An invention is new. This is, I'm reading from the Act. An invention is novel, right? Is considered new if it is not anticipated by prior, which means everything disclosed to the public anywhere in the world or the contents of a patent application previous prior. So your examiner is going to look at patent application, right? They'll thoroughly go through a patent database, and there are several patent databases out there. You have the USPTO database, you have the European Union database, you have WIPO has the database. Every country, so many of the leading economies in the world have put their patent databases online, so you can go and check, right? Sometimes you may look for an invention, you may try to apply for an invention, but that invention may have been invented prior to you in China. Now, how do you know it? Because the entire Chinese database is in Chinese. But you have a duty to go and check under the search headings of your invention to see whether this invention exists or not. Because if it is found to exist in China, right, and if that Chinese application was made prior to your application, a team of lawyers, if they find that, can bring it to the court in which your application has been filed, bring it to the country in which your application has been filed, and seek for nullity of your application or nullity of your patent, even if it's granted, on the understanding that this technology already existed abroad, right? So you have to be very careful and you need to do a patent search. Now let's go into industrial designs. Industrial designs govern the shapes of objects, right? And it's meant, it has been created for aesthetic purposes. Now, patents govern function. It governs the idea, it governs the invention. Now, industrial designs govern the shapes of objects. Now, why is this important? Because like a trademark, sometimes shapes distinguish the product from its competitors, right? Now, look at the Coke bottle. The Coke bottle has a very unique shape, right? Now, that has been done purposefully to distinguish the Coke bottle from other bottles out there, right? So that becomes part of its identity. It itself becomes a business identifier, right? And if you're clever in product development, you will use trademarks, copyrights, patents, and industrial designs for maximum gain. Now, what is an industrial design? Once again, it is the right granted by a state upon an application, which gives exclusive rights to the design. It applies to any composition of lines or colors or any three-dimensional form that gives a special appearance to a product of industry or handicraft and is capable of serving as a patent for a product or industry, right? This is very industrial design. It governs the shape. Now, sadly, I don't have anything of that to give you an example of, but let's think of the Coke bottle. The Coke bottle has a unique shape, right? So I don't know whether it has an industrial design as yet, but I'm sure it does, right? Because Coke generally is very careful about its intellectual property rights, right? Now, those are the 4 IP rights there are. I'm rushing through this because I've got about 10, 15 minutes more because it's a 1-hour lecture. But now we went through 4 different types of intellectual properties. All of these are protected by the country to which it's applied for, except copyright, where copyright has universal application, right? So if by chance someone copies my book that I wrote in Sri Lanka, in the UK, I can go to the UK court and sue on that. But for an industrial design, a trademark or a patent, if I want to sue people in those respective countries, I need to get an application in those respective countries to also have exclusivity for my product in those each other's respective countries. That's very, very important. Right? Now, one thing you have to know about IP is not just a shield that protects you from this, it's also a sword, right? The only way you can really protect your IP and stop people from exploiting your IP is actually if you go out there and stop them, right? Now, in the musical case that I spoke to you about, right? One party was claiming rights, the other party was claiming rights. Both parties came to a stalemate. Both parties said they have rights to this song, right? One party said, this is our song. The other party said, this is their song. Then how do you separate this? If you allow the other party to copy, right? And if they continue copying it, well, then the public will assume that that song belongs to them. So what did the plaintiff in that case do? The plaintiff went to court and said, no, this is my IP rights. I was the first creator of this, and this is therefore my song. So to enable IP rights to be your own, you also need to be ready to assert your rights, because it's called rights. You need to assert your rights to that piece of intellectual property. And only then would you have exclusivity in a marketplace, right? Now, let's talk a bit about undisclosed information. This is a tool that some people go to court on. Let's talk about undisclosed information. What undisclosed information is, it essentially means the trade secret. And under the Sri Lankan Intellectual Property Act, you can go to court if I have shared a secret with someone on the specific understanding that that person keeps this information confidential. And if that information does not exist anywhere else in the world, and that information is completely proprietary to me, and I have specifically told you, look, do not share this information, then I would have a right against that person, possibly by way of an injunction, to prevent that person from sharing or exploiting or using or creating products through that specific piece of information.
Revan, just one interruption now. Assume that you transfer one of your know-hows or a trade secret to someone else, as you just mentioned. Yeah. And then if he violates, you go to courts. And at that time, do we have to expose what the trade secret is, or how this is being conducted in the courts? Like,
so that's a bit of a catch-22 situation, because I suppose you have to disclose it to some extent to prove that it has been disclosed. So generally people go to court because it has been disclosed, or people are good to use that information, and you can demonstrate to the judge, this person knew this information, now this person is putting it out to market, right? So for example, now this particular section has been used in instances where people people have worked in a company, technical people, they know the technical products, and now they've gone and set up a competing company, and they are going to create, they are putting to the market similar innovation to what they have specific undisclosed information of or regarding. Then at that point, you can go and get an injunction without divulging it, but saying, look, there is a imminent possibility that these people are going to disclose this piece of technology because they are going in this direction, right? I want a injunction saying, look, you can't put out this particular piece of technology, or you can't exploit this particular piece of technology because it is governed by undisclosed information. And it's governed, and that constitutes an act of unfair competition. So, good question. It's not used so much for the same reasons that you mentioned here. But if there is an imminent chance of disclosure, then it's more business decision than a legal decision. Then you will go to court to prevent someone from disclosing. Did that answer your question, Lakshita?
Yeah, thanks.
Okay. Now, moving on. Now you have these 4 bundles of rights, right? Now, what are the rights that emanate from these rights? One is the right to assign, right? I can sell my property, my intellectual property to Lakshita. I can license my intellectual property to Lakshita if he's wanting to, say, if it's a software, I can license it to several people, to your entire classroom to use that software. Or I can exclusively license it only to one person, right? Only I then also have the right to reproduce. If someone reproduces my book, I have a right to sue them. Only I have the right to authorize someone to translate my book, right? Someone translates it and sells it, I have a right to prevent them by way of injunction. Only I have a right for public performance of my work, right? And I have a right to prevent others from doing that. Only I have a right to broadcast my music, even though that is completely abused in Sri Lanka, at least, because we don't have a society that licenses music to radio stations, which is somewhat of a problem. You get artists' songs are sung on stage by other people abusing their copyrights because a lot of artists choose to look the other way. But however, in a more mature, in countries where IP is respected to a higher degree, you can't even sing a song on stage, right, without giving the artists royalties for the use of this song, and that is governed by various mechanisms, right? Then you have the right to have your name indicated and to object to any distortion of your work. If I have created a song and if someone remixes that song, I have a right to prevent that person from doing that, because my moral right is abused at such an instance, right? Then I have also the right to ask whoever that's putting my work out to credit me for my work. But most of all, the biggest rights that emanate from intellectual property is you have the right to prevent others from using my work without my permission. But once again, keep in mind, trademarks, industrial designs, and patents are territorial. You can only exert your rights on countries in which you have gone and got a registration. So that's very, very important, right, to know. Now, how do you enforce your IP rights? You can get an injunction, which is an order from court preventing someone from using that piece of work.
Excuse me, Revan. Another clarification needed. Now, assume that I patent one of my technologies or IPs in Sri Lanka, but then that becomes a prior art for another country, right? I mean, someone from America would not be able to get a patent on the same technology, right?
Repeat that question, Lakshita.
No, I get a patent rights for one of my technologies in Sri Lanka from Sri Lankan IP organization.
Correct.
So someone from that prevents someone from another country coming
from
up
patenting
with the same technology and patenting it, right?
Yes. And if they have, and if it's been wrongfully granted, you can move for nullity in that country.
Yeah.
So, on the basis that it's been wrongfully granted.
But that doesn't mean that they can't use that technology for another purpose, right? If they
Correct,
they can still use it.
No,
right, thanks.
Yeah. They can't use. Well, if you don't have a patent in that country, then they can use it.
But they can't patent it.
They can't patent it. Definitely.
Because my patent becomes prior to for them, right?
Correct. Thanks, Lakshita. Okay, so do we have time for this little exercise? I just want to take you on a little
Yeah.
exercise,
Yeah, we'll do that.
right? With regards to where Sri Lanka stands at the moment, right? Now, China has a population of 1.4 billion. India has a population of 1.4 billion. And these countries sell a lot of the produce that Sri Lanka does in time to come, like textiles or software or rubber value-added products and various things like that, right? But the advantage China and India has, and Bangladesh and Vietnam and various countries like that, is that they have what's known as economy of scale, because they're giant companies, right? So if you guys look at some of the websites that now we have access to, like, for example, Daraz or even this Temu thing that has come up, you will find like really good quality clothing being sold at cutthroat prices, right? $2,000 for fantastic shirt, $2,000 for a fantastic trouser. Sri Lanka is also in the business of apparel, though, right? But we face to face see the results of economy of scale. That, especially now with e-commerce, is even intruding into our local market. But let's talk purely from an export market point of view, right? We sell tea, we sell rubber, we sell coconut, we sell spices, we sell gems, right? Mostly commodities. We sell apparel, right? But these same products are also sold by these giants that have economy of scale and many other competitors the world around, like African tea is now becoming very popular. Question is, A, they can be more price competitive than us because they have economy of scale. How do we compete? And how do our products become more relevant in a global marketplace? Right? And this has been a problem that really has puzzled me for the longest time. Because I foresee that this is going to impact our economy, and it has impacted the economy for a great reason. This is why we had a financial crisis also over the last couple of years. Right? Simply being unable to compete because we are outpriced. Now, if one is to create a strategy for differentiation, I would honestly advocate that we go down the technology differentiating path, the branding differentiating path, the copyright building differentiating path, essentially the path to create IP. And create IP that will make our products more relevant in the global market. So that means tea that has different flavors, tea that has different brand value attached to it, right? Apparel that has different technologies attached to it. Apparel that is, which is why companies like Slintech was set up in the first place, right? And most of our research companies were set up in the first place to create differentiating products and put it out to a global marketplace. And this is how I foresee how IP can change direction of companies and countries because the value addition it brings to the table, right? Now, I would like to speak about the example of America, not for any other reason, not to venerate them as being a massive success story, but simply because you and I use a lot of American products. Now, if you look around the room, many of you all, I'm sure, have Apple iPhones, right? Many of you all use Apple computers. What is the distinguishing feature of Apple over many other products, right? One, I would say, is its brand value, right? And that goodwill has been created because Apple products allegedly don't break, right? To be fair, I had a laptop that I used for 12 years or 13 years. So they've gained a reputation of quality. And a lot of these companies are innovative. Now, if I'm to share a few brands that the US have, you would realize that you and I use a lot of these products. And we're very familiar with their brand names, right? They have created quality brands that you and I know, and they have sold it internationally. But if you break down these companies, you would see that most of these companies have invested heavily in intellectual property, right? And that is what gives it its edge in the global marketplace. For example, Microsoft, right? Coca-Cola, Goodyear, 3M, Nike, they're all very innovative companies, extremely innovative companies, right? And they have all pursued an innovative sort of approach to the global marketplace. They have, how should I say, they have always been innovating their products to build more and more value, right? And that is how America, with a population of 300 million, 328 million, has been able to stay competitive against countries like China and India and the rest of the known world, even Europe, right? So you see that countries that move along the line of technology development, move along the line of product differentiation, move along the line of working on the cutting edge of technology, what we call the cutting edge of technology, have been more successful financially and strength-wise than countries that merely sell commodities or merely sell natural resources. So if you look at industrialization, you have to go up that ladder. You have to go from strength to strength, and I call that development of IP. I call that development of IP. Now, if you look at McDonald's, it's a well-known mark. It is known the world over, right? YouTube, you and I all use YouTube. So you have the world's resources or the world's funding if you think innovation and if you think big and if you think of making a global product, right? And I honestly feel this should be the direction that Sri Lanka should take in order to remain competitive, that we leverage on intellectual property, creation of intellectual property and royalties in order to be more relevant, right? And for that, we need think tanks like the people at SLTC to make this a success, right? Right. So why is IP important to business? I think I just answered that question because IP gives you an edge. IP gives you exclusivity. IP gives you a differentiating product. IP gives you some value. It gives you additional value to just selling commodities and selling natural resources. Like what? Well, we need to move away from that, right? Main advantages of IP is it gives you an exclusive right to use, an exclusive right to sell, an exclusive right to license, and a right to prevent others from doing the same. Right to franchise, right? McDonald's, Starbucks, all that is examples. Examples of companies that use its own IP to generate profits. Well, you have the BMW Empower engine or BMW Tech, DJI has used their drone technology. They keep on developing their drone technology to make their own products better. Right? Apple keeps on making its own products better. So it's innovating at a daily basis on a massive rate to make their own products better. Right? IBM at those days used to have the most amount of patents. IBM used to file something like 8,000 odd patents a year. Right? That's simply because they were constantly innovating to be at the cutting edge of technology for the purpose of creating bigger and better products for the marketplace. Examples of companies that license Microsoft, it's one big licensing agreement. Right? There's one software, we all license it from Microsoft and we all pay royalties now on a monthly basis or a yearly basis or any way you want. Right? How does Facebook license? Well, it gives us the technology for free, right? But people that want to advertise on that can pay the company for the usage of for advertising, right? Netflix, it's a massive licensing model, right? All these companies license. Then companies that franchise, McDonald's, KFC, Coffee Bean, we see it over and over and over again. I'm waiting for a Sri Lankan franchise. I think there's a Sri Lankan franchise called Curry Bowl that is making some headway in a few European countries, right? The biggest advantage of IP, I would say, is profit and passive income. If you write a book, right? If you write a piece of software, if you license a patent, people, every time they use it, they pay you, right? But I would say the key component that's missing in creating great IP, phenomenal IP, is the inventor or the author's perception of its real value. I think every author or inventor that goes into creating something new needs to ask themselves, what is the real-time demand for this product, goods, or service that I'm putting out in the market? Why am I creating? Who will benefit from this? What is my target demographic? I think if we are to make a real waves in the marketplace, we need to keep asking ourselves that question before we create something, before we put it out to the marketplace. Who would be the users of this product? And what would be the real demand of this product? I mean, I'm a big fan of Chris Reiser's book, Lean Startup, or his thoughts on Lean Startup, where you need to test your hypothesis. Would this sell? Is this, why am I innovating this? Right? And test it in the marketplace. But anyway, getting back to IP, the biggest advantage of IP is profit, passive income, and you create something of value, brand value, right? Few other slides. I think if you are to be innovative, right, you need to build surrounding your processors. You need to be these key elements of information security. You need to leverage on IP. You need to leverage on data. You need to create an IP enabling environment within an organization to share ideas. You need to idea generate, idea evaluate, right? But now I'm moving away from IP. But let's talk for a minute on how to take IP to a foreign marketplace. Like I said, IP is territorial. So you need to check for potential of your IP. Does your IP exist in the marketplace in which you're going to go? Can you get a patent for your technology? Does it already exist? Can you get that same trade name in the country that you're wishing to take your products to? Right? You need to plan, check the potential of your IP, and then protect your IP in each of those different countries to which you're going to take your products before you move ahead. So right at the very start, when you're starting your research cycle, when you're starting to innovate something, when you're starting to product develop, when you're starting to create a new product, you need to think of where you're going to take this product finally. how you're going to exploit IP. How are you going to get your profits from what you're going to take, right? For that takes a lot of data, but the more you plan ahead, the more value you bring to the table, right? Because if you don't plan ahead and you create something that already exists, right, then you're just wasting 2 years or 3 years of your time creating something that already exists. Because you're unable to take it also to a foreign marketplace that has a mature IP sort of ecosystem, right? And yeah, on that, I would open it for some questions. I'm sorry,
Thanks, Revan, for the wonderful presentation. I think it was a great presentation. So, are there any questions?
I have one question. So, can someone inherit IP since it's an intangible asset?
You can. So, say Clarence Vijayawardhana's songs all went to his family. So any artist, any creator of intellectual property, you can either give it by way of a gift, or anyway, we have a default system where it goes to the estate and the estate gets divided, even if there is no will.
Even if it's a patent that happens, right? That can be.
Yeah. But say first thing is, if you're an inventor, just put it. You can put it in your will, or you can, write it to someone, assign it to someone. You can even assign it to someone. That's a safer way of doing it.
I have one more question. Like, how does the copyright enforcement work in cover songs? Because every day we hear cover songs. Is there any fair use of it?
Yeah. So there is a regime called fair use, right? Fair use would be there is no fair use with regards to music. Fair use governs criticism, governs educational, for the purpose of education. I'm sharing, say, Lakshita's book, I'm critiquing it, I'm sharing it with you all, right? But if I can't commercially use Lakshita's song and profit of it by singing a cover, because I'm commercially profiting it off it. Generally, covers are governed by a license arrangement, or you have an understanding. Look, I'm just performing it as a cover. There is no harm caused to you, please. And most artists look the other way, right? But if you want to be very strict on it, then you have to go through a performance society, or a society that governs, musicians' rights to sing a song. And then there's a small agreed upon royalty that's paid to the musician every time you perform their song at a function or a wedding or a concert.
Thanks, Jan. Are there any other questions? It has to. I think you have to take the consent from the original artist if you are doing a cover, right?
Ideally, yes.
Yeah.
I have one question.
And you have to attribute ownership to that person also. You have to credit that person, saying this is their song and I'm singing a cover of.
Are there IPs related to gastronomical tourism related stuff? Because some countries are heavily on their own food, like Nasi Lemak, Pad Thai, certain countries. So are there any right related to that?
Yeah, so you may be I didn't understand your question perfectly, but you may be talking about geographical indicators such as champagne from Champagne, which is a geographical indicator that says wine from the region of Champagne has the right to use the word champagne against the sparkling wine that they sell. Right? Is that the question that you were trying to say?
Yeah. So where does Sri Lanka stand in that case?
So a geographical indicator would be, well, Ceylon tea, I think, has got a geographical indicator. in
On
relation.
cinnamon as well, I guess.
Yeah, but the government has to move for that. The government.
So government means the Ministry of Cultural Affairs?
I'm not sure which ministry would have to act.
I think, thank you very much, Mr. Revan Weerasinghe. I think it was a great talk. So we will share this with our academics as well. And also we want to engage with our future programs as well. Because you are one of the few IT lawyers in Sri Lanka, the country has. So I know how SLTC gets benefited because of the service of Mr. Revan. With his busy schedule, still he spends at least half a day a week at SLTC. So we were immensely benefited because of his commitment towards the country. Because when he says that Sri Lanka should work on creating more IPs and then generate revenue through that, he really means it and he believes it. I really know that because I have been working with him for a long time. In different ways. I worked with him as a scientist, as also as I handled the business development and then the technology transfer divisions at SLTC. So we worked on a lot of agreements together. Sometimes we had some we had different views, and then we discussed. So we had a very good relationship. I really appreciated that at this moment, and thank you very much, Mr. Weerasinghe, for your service for the country. And to formally thank, I would like to invite Janaki.
Thank you, Mr. Revan Weerasinghe. So we appreciate your time and the energy that you have invested on us. I mean, it's been a wonderful session and much needed topic to be discussed. So thank you once again. And I thank our management for their leadership and Dr. Lakshita for his concept on these emerging scholars and connecting the dots. And last but not least, I thank all the participants who have gathered today. Thank you. Thank you, Mr. Revan.
Thanks, Lakshita. Thanks for the invite and to the SLTC team. I really have heard some wonderful things about what y'all are doing. So I'm excited to one day come and see
We will
the
definitely
work
invite
firsthand.
you.
And I know if Lakshita is behind it, it's going to be excellent. So yeah, looking forward to that.
Thank you, Ranshra. Thanks. Bye.
Thanks, Lakshita. Thank you, everyone. Bye.